What's up, everybody? Okay, you're watching Dad versus CPS. You know the whole introduction, right? This is Michael here. Okay, this is a very important video, guys. Like seriously, it really is because I'm just gonna be straightforward, okay? And if people's feelings get hurt, okay, I'm just gonna tell you straight up like how it is, okay? And And in this case, okay, so I'm going to be explaining to everybody a process that me and my friend John Whittington Jr., okay, and what we were doing in state court and federal court, okay. And this video is on a topic called the Affidavit of Repudiation and Revocation of Citizenship, okay. So this is a very serious subject, right? Because most people don't understand this process, okay. Apparently, with this document, okay, you're able to step out of the jurisdiction of their court, right? Because the only reason why that you're in court is because you're either a resident, a citizen, or a legal person. And with this document, if you do it the right way, and especially the way that David explains it, okay, then you're able to step out of their ability to pull you into their jurisdiction, okay? But you have to do it correctly, okay? And in this case, we did everything correctly. And just to prove to that, right? Because people just want to be talking all kinds of crap on Facebook, right? And even on YouTube, okay? And Michael, did y'all do it the right way and all this and that? Okay, so first of all, okay, John reached out to David himself, okay, for the actual instructions on how to do the affidavit of repudiation process. And David instructed him, okay, just like he does to everybody. Okay, if you call David, if you reach out to him, he'll tell you how to do it. Okay, it's no secret. Okay, but I'm going to show you here in this video, okay, an actual recording of me and David straight. I want to say back in 2018, right, or 19, right? Um, I'll go ahead and post the date of this recording in the description. Okay. But point is that I knew how to do this, right, with this exact instructions. Okay, it's for some time already. Okay, and I just never made a video of it specifically, right? So to give out the instructions correctly, okay, in the steps that we followed, both me and John, I'm going to post that video right now. Enjoy.
Would you feel like it would be too much of how do you say, like, would it be bad for me to know how to do it and actually explain that in videos, or is that something that you would recommend me not to do? Because I
I
don't
don't
want
care whether you do that or not.
I don't want
I
to
think
I
it's
don't
a
want
benefit
okay, I just don't
if
want to,
you
like,
learn properly.
yes, I just don't want it to
So,
have a bad effect on what's happening to, like, the good things. You know what I'm saying? Like, I don't want to do something. I want people to know, like, exactly how to do it. And if I can teach people, like, I wouldn't mind doing that. You know what I mean? Like, this has
right.
the word of mouth is so powerful. Like, that's the greatest thing you can have, man. And the one thing people really, really wish is why can't there just be a video on that, on anything or whatever it was? You know what I mean?
I have a video on going through the documents and talking about the documents, and I don't know what keeps happening to it. I think Facebook keeps removing it. I think YouTube keeps removing it. It just, they don't want people to know, and
Yeah.
that's part of the problem. That's one of the issues we're fighting constantly. But regardless, the affidavit of repudiation should be sent to the Secretary of State of the United States.
Okay.
That's all the United States Code says it has to be sent to. Now, personally, I send it to the President. I send it to the Secretary of State as I'm required. I send it to the Attorney General. I send it to the Attorney General in the state I was born, which was California. And I send it to the Attorney General of the state I live in, which is Oregon. Why do I do that? Because I want them to know why I'm doing it. And every time there's a regime change, I send it out again to whoever the new guy is, because I want them to know it. Okay? When you send out the affidavit of repudiation and you get your green cards back in the mail showing proof of service that they signed for it, now you can attach that proof of service to a certified proof of service form and attach that to the top of your affidavit. After 21 days, you do a certified judgment of unrebutted affidavit, and you attach that to the top of your affidavit of repudiation. Now, that document could be used as something you have previously done in the law. See, previously is the fourth most important word in the law. Why? Because anything previously done is a civil matter.
Is it what? A civil?
So you can walk into a... What's that?
You said everything that's been... It's a civil matter? Is that what you said?
Is a settled
okay.
It's settled. It's done. You can't argue it. Okay? So now you've got a document that you can walk into a courtroom, you can throw your hand up like a school crossing guard stop sign and say, hold on just a minute, Judge. You can't presume that I'm a citizen, a person, and a resident, which is the three things that you need to have tacit agreement of in order to proceed and have jurisdiction, when I have previously in the law repudiated that matter, and here it is, the settled judgment in the affidavit, and you throw it down on the damn counter. See?
And that's not even stating anything about anything that happened.
Now he has no jurisdiction. You say, I'm hereby challenging jurisdiction. Now, in the beginning, you don't walk into a courtroom and you don't say your name and your address. You never say your name and address in the court. You say, I'm here by special divine appearance only. Calling for a constitutional court of record, asking for a summary judgment of the truth and facts upon the record via my affidavits. Now they can't do a damn thing except do a summary judgment on the truth and facts that are on the affidavits. And since your affidavits have gone rebutted, they become the judgment in the case. Case dismissed.
There's not
Is
even...
how easy I just won that court case?
Wow, and that's not even explaining anything about my kid and anything. Like, so they know exactly what...
Me and Michael worked on a lot of documents for the state court because they were having a jurisdictional hearing, right? So with that being said, you know, these idiots don't even know what jurisdiction means, right? They don't, and it's just appalling to me because, you know, even if we go over to the rules of California court, right, and this is updated as of 2021, Rule 1.42, right, forms not to be rejected. And if you go and look at it, you know, with our paperwork, we meet everything in there. So the judge was sitting there calling it unlawful and incompetent, right? That he couldn't understand them. He admitted it. Now, the thing why this matters is, if this is what happens to you, don't even bother with stateside. Just go straight to federal. And it's the best money you'll ever spend, unless you can get a fee waiver somehow. But either way, just make sure your paperwork is done right. Because state courts, they don't care. They really don't. There's been a lot of terrible things they've been doing to me and my family, especially to my kid.
Okay, guys. So in this document right here, I'm going to be showing you. This is John's case in federal court. Now, John has asked me not to show his case number or his cause number in state court because that's actually still open right now. So I'm going to respect his wishes. Okay, but we want to show exactly what happened in federal court. You know, in his case, right, after using the Affidavit of Repudiation and another document titled Notice of Special Divine Appearance, Standing, Status, and Dominion, right? So I already showed you out that document, okay? But this is now the outcome of that, right? When they actually ordered granting motions to dismiss filed by defendants Willis Bubis, who was a judge, and Zabak, who was an attorney, and denying as moot motion to dismiss filed by defendants Villavana and Johnson. Okay. All right, so everything got dismissed, right? Case closed, right? Basically, that's what it is, right? Okay, so let's go on to read this document, right? Because I want y'all to understand what happened and what was the outcome of using the affidavit of repudiation, right? So it says here, on July 7th, 2020, pro se plaintiff, right? You must go pro se if you want to sue someone in court, right? That's just the way it is. There's no way around it. If they're coming after you in court and bringing you to their court, then you're a sui juris, apparently, right? But in this case, John went in pro se, right? So on July 7, 2021, pro se plaintiff John Joseph Whittington filed the present case in this court, okay? Plaintiff initial 70-page complaint named Lisa Daines and Jennifer Rose, those were the caseworkers, the social workers, as defendants, both of whom are alleged to be employees of the County of San Diego Child Welfare Services. Okay, the plaintiff alleged Daines and Rose removed plaintiff's son, Carson Whittington, from the custody of Joseph's mother, Haley Autumn Herring, pursuant to a protective custody warrant issued by the state court. Plaintiff claims were difficult to decipher, but liberal construction of the complaint suggested he was trying to allege a claim under Title 42 United States Code, Section 1983, arising from Joseph's removal from his mother's custody. Okay, and a 224 first-page amended complaint, FAC, filed on July 22nd, 2020. And the reason why they're saying that it's so big, because apparently something happened with John's first initial complaint, which was 70 pages. Okay. And they did all of the wording wrong, the format, right? They didn't bring in all the defendants, which there were many, right? And so he had to go back there and amend some things. Okay. So let's go back to line 26, right? In a 224-page first amended complaint of FAC, that's what that means, right? Filed on July 22nd, 2021, plaintiff appears to reallege the same or similar claims against Daines and Rose, and names as additional defendants Priscilla Villafana and Priscilla Villafana. Okay, she is a social worker right now, right? And Leonie Johnson is the actual attorney for the department, right? For the social services, right? But so now we go on to say where it says both social workers employed by the County of San Diego, okay, Catlin Martin Jones Zabek, okay, so he's an attorney, right, at the Children's Legal Services of San Diego, and San Diego Superior Court Judges Browder A. Willis III, who presided over the juvenile court proceedings concerning Joseph, right? See the first initial complaint, right? At 217 through 18, and Gary M. Bubis, who issued the protective custody warrant, right? Because at first what happened was that John went in front of one judge, okay, and he was there with his parents, right? And while he was there at his parents', okay, his dad actually noticed that the judge on the bench actually was his attorney at one point in time. And because of this, they said that there was a conflict of interest. And so the first judge, okay, actually recused himself, okay, from the case. But there was another judge that was appointed, okay. So now let's go on to line 6 on page 2, okay. So in response to the FAC, the first initial complaint, Judge Willis and Bubis filed a motion to dismiss. Okay, so defendant Zabak filed a motion to dismiss and or a motion for a more definite statement, and defendants Villafana and Johnson filed a motion to dismiss, or in the alternative, a motion to quash for improper service. Okay, so let's stop right there at line number 2, right, on page 2. And the reason why they're actually filed that motion to quash for improper service, okay, let me explain, right, so that everybody can understand what's going on, is because John was trying to serve the caseworkers, okay, and we didn't know where they lived, okay, but what we found on that program been verified, right, and I thought it was going to be pretty accurate. But I also know that we can actually serve the social workers at their place of work, right, where they work. And so he did that, right? He sent it out registered mail, and he's got his green cards back for that because they signed for it. Okay, so he's got those green cards back as a proof of service. Okay, but the thing is that he also attempted to serve them through personal service using his own hired process server, right? And that process server, okay, went to the office and talked to one of the employees that worked for DCFS and left it at the front desk, right, with someone, okay, and because of that one mistake, okay, they were arguing that they were not properly served, okay, but keep in mind though, okay, that's not the only attempt that John had done, okay, he also had it sent over via United States Postal Service, and they signed for it. So he had at least one proper service that was done according to the rules of civil procedure. Okay, but let's go on to page 2. We're on line number 9. Okay, so plaintiff did not file a traditional opposition to any of these motions. Okay, so at that point, when they had actually filed this motion to quash for improper service, okay, I guess John didn't know how to respond to that. Okay, so it kind of just was left like that, right? So it says that, but he did file an affidavit of truth and declaration of John of the Whittington family, right? Followed by the affidavit of truth and facts by John Joseph Whittington in support of default judgment. Okay, so John was actually trying to put them in default to his actual initial complaint because they actually didn't respond to his first filed document, right? So he was trying to default them, right? So Judges Willis and Bubis filed a reply brief to their motion, as did defendants Johnson and Villafana, right? Defendant Zabek did not file a reply to her motion, okay? As indicated in the motions, defendants raised a number of arguments that could potentially justify the dismissal of case, ranging from judicial immunity to the Rooker-Feldman doctrine. First and foremost, however, is Federal Rule of Civil Procedure 8, okay, which requires that a claim for relief contain a short, plain statement of the claim showing that the pleader is entitled to relief, right? And this comes out from Federal Rules Civil Procedure number 8, Rule 8A2, right? And that each allegation in a pleading be simple, concise, and direct, right? So that's out of the Federal Rules of Civil Procedure, Rule number 8, D1. Plaintiffs' 224 page, right, of their first, their FAC, right, satisfies neither of these requirements. Indeed, the FAC is comprised of a variety of apparently separate documents, including a notice of special divine appearance, status, standing, and dominion. Okay, that's the document that came from David Strait. And John just put his name on there, and it's just switched it out. Okay, but we're using the method that's being presented to us, right? Because that's all we have, right? So he put in his notice of appearance with a notice of special divine appearance, status, standing, and dominion. Okay. So the FAC at 4 through 10, which cites Bible verses, as you can see, right, in David's document, it does do that, right? He's citing biblical verses. Okay, so on line 24, okay, so another affidavit of truth, SIC, and fact, ID at 37 through 41, a notice to any available federal prosecutor, SIC, 90 days decision to prosecute. This was a conversation that me and David Strait had, right? He had explained to me at one point, telling me that on how we can actually sue the government officials, right? So long as we just gave notice to a federal prosecutor, 90 days notice. And if they didn't do that, federal law said that we would be able to prosecute them ourselves, right? But obviously, you know what? We just did the document. We filed it, okay? So let's go on to the next line, right? So the page numbers cited here refer to the pages numbers assigned by the court's CM-ECF system. Right, so now we're on page 3 of 4, right, on number 1. So, let's see, the court system, okay, to be printouts of, and you know what, actually, it's gonna jump from 25 to number 1, right? So the last sentence should be 90 days decision to prosecute what looks like to be printouts of various government web pages, right? Documents filed in the juvenile proceedings in state court, ID at 61 to 68, a 32-page affidavit of truth. Here's where, okay, that's where it is. Okay, on line number 2, that's where it talks about David's affidavit of repudiation, right? A 32-page affidavit of truth and assertory oath, repudiation and revocation of citizenship. Okay, a criminal complaint form filled out by the plaintiff, right, and arrest warrants for defendants Rose and Daines, right? Okay, so what we had also done in John's case, right, is we wrote some arrest warrants up, right, and arrest affidavits also, and we had those notarized too, and we were just filing to the court, right? We were trying to get something done, right? Me and John just went all out. We really did, right? So on line number 6, it says, the FAC also contains terminology, okay, that suggests plaintiff may subscribe to the sovereign citizen ideology, right? CID at 71, being sui juris, right? That's where on John's affidavit of repudiation, right, it says John Joseph Whittington Jr., sui juris. That's what they're talking about, okay? Referencing plaintiff's attempt to revoke his United States citizenship. And then it goes on to say, bring up some case law saying that courts across the country have uniformly rejected arguments based on the sovereign citizen ideology as frivolous, irrational, or unintelligible. And that's coming out of some case law, Mackey versus Bureau of Prisons, right? And then it gives the actual case number, right? Number 1:CV-1934-LJO-BAM, right? And that's where you can find that located, right? So I'm just going to skip on to the next part, right? Where it's also citing another United States versus Staten, right? Number 1:0-CR-179. These are all case numbers where you can find these actual case laws, right? Where the Ninth Circuit has also rejected arguments premised on the ideology as utterly meritless, right? Utterly meritless, right? And that's coming out of citing United States versus Studley, and then that whole section, those numbers right there, that's just where you can find that, right? So now we're on line 15. So here the court agrees with Judge Willis and Bubis, right, and defendant Zabek that plaintiff's FAC is subject to dismissal because it fails to comply with the Federal Rules of Civil Procedure 8A2 and 8D1, right? So the court also finds plaintiff allegations to be frivolous and subject for dismissal for that reason, right? Also see Wallace versus Lynch, right? And then that's the case number. Okay, so we're here on line number 1 on page 3. Okay, so where it's actually citing, it starts off citing a case, right? Franklin versus Murphy, right? And that's the whole site number right there, right? Where a complaint is obviously frivolous, right? The district court may dismiss the complaint, right? Even if the plaintiff has paid the filing fee. You see that? So that's kind of the reason why we had chose to pay the filing fee, right? Because it gave it more standing and merit, right? At least that's what I thought, right? But they went over here and said this, right? So that's why I wasn't trying to get the filing fee waived. But anyways, it says the district court may dismiss the complaint even if the plaintiff has paid the filing fee, right? Accordingly, the court grants motions to dismiss filed by Judges Willis and Bubis, and the motion to dismiss filed by defendant Zabek, and dismisses the case, plaintiff's case with prejudice, meaning that John can't even bring this back up in this case anymore, right? And possibly in any other case, right? So C. Mackley, 2016, WL, and then all that stuff right there, right? Dismissing plaintiff's complaint because it was legally frivolous. So it was ordered December 3rd, 2021, and then signature there by the United States District Court, right? Honorable Dana M. Sabra, Chief Judge, right? That's a signature, right? So the point is, guys, is that, okay, this was the outcome of filing the affidavit of repudiation, the notice of special divine appearance, standing dominion. They just said that it was all sovereign citizen ideology. It had no merit. It just completely destroyed his image, right? Had he not filed those documents, I think that it would have been a complete different outcome of the situation. But anyways, guys, I just wanted to just let y'all know what it was that John had done, we had done. It's just crazy on what happened, right? But I mean, we want to share our mistakes, and hopefully nobody gets done like this, All right, guys. So I'm gonna go on to continue to explain what else we had done in his case. Give me 1 second. Okay, guys, so let's go back to John's case back in state court, okay? So like I said before previously, John has asked me not to give out his address, and he has asked me not to give out his case number. So I'm going to respect that, okay? Because John's actually allowing me to teach y'all, okay, what happened, okay? So here's what happened, what they said in state court. Because remember, we filed the affidavit of repudiation in his case too, right? So these are the list of the documents that at the bottom, right, which says enclosures, that the court actually received. But first I'm going to go ahead and read this letter, right? So it says, Dear Mr. Whittington, okay, the San Diego Superior Court has received numerous documents listed below from you. These documents are not in compliance with the requirements of the California Rules of Court. They are frivolous documents being submitted for an improper purpose and are of no legal force or effect. As a result, these and any similar documents submitted to the court in the future will not be filed or otherwise acted upon. Submission of these documents, okay, does not excuse you from any applicable legal obligations, procedures, or any court order in your pending case. You will receive no further correspondence in response to this type of submission after this letter. The documents are being returned to you, and they actually literally mailed them back everything that we filed, right? And it was a pretty big list of things that we had filed, right? Okay, so the very bottom one, okay, that's underlined, okay, that's obviously the affidavit of truth and assertory oath. That's the affidavit of repudiation, right? Because that's how it's titled, right? And that was 32 pages, right? And John filed that, okay? It was one of the very first ones that he had filed too, because you could see where he filed it on March 18th, 21. Yeah. Okay, so yeah, he filed it pretty early on in the case, right? Because everything else you can see where it is around the 6th, right? Whatever. The point is that we challenged the jurisdiction. We fired the attorneys, right? We did a table of contents, right? We gave them an affidavit of status, which included the affidavit of repudiation. But the whole point of this video is just to show people that document, the affidavit of repudiation and revocation of citizenship, really didn't have any effect in state court either, right? However, John's court is still active in state court, right? So I guess I'm kind of limited in talking about that case because obviously it's still open. I don't want to respect John's wishes, but guys, you should really, really consider if you're thinking about doing this process, right, or using these documents in court, right? This is the outcome, or this could be the outcome of your case, right? And And so although we were led to believe that this might have worked, and in this case it didn't, but you know what? I'm still going to give an opportunity for people to come forward to let us know if this process has worked in their case, and if maybe we did something different and they did something differently too and it worked for them. Well, to please come forward and please let us know, because I mean, in the end, we're just trying to give out the right and correct information. And well, I hope that this video has really give y'all a more broader idea of things that are going to happen and could happen. In this case, it did happen. But anyways, y'all take care. You're watching Dad versus CPS. Over and out. Okay, guys. So this document right here is titled "A Notice of Special Divine Appearance, Status, Standing, and Dominion." Okay. Now this document comes from David Straight. Okay, so my friend actually emailed this to me from David Straight, but this is also found in on his USB that you can purchase. That's at his website. So this document's out there, right? You can even email David Straight, and he'll email you this document himself, right? If you keep in contact with him, right? But the whole point I'm putting this document here is because this is one of the documents that John filed in federal court. Okay. Now we all know what David said, right, in the video, right, that I just showed y'all, that you never say your name or address at first in a courtroom, right? You never say that, he says, right? You say that you're there by special divine appearance only, right? Calling for a constitutional code of record, and okay, we know the whole segment, right? Okay, but the point is that everything that you speak in court, and just so y'all know, okay, you must state whatever you're going to speak about in court in writing. So this document is the whole point of that, right? It's a notice of special divine appearance, right? And so that's what we're talking about with this document, right? This is what John filed, and so I'm going to be going over this with you, right? Because this was one of the documents that was actually canceled, right? But this actually comes from David Straight, and so it's right here. I'm gonna go scroll through it real quick, and I'm going to actually put a link in the video, so you can actually click on it and you can download it and you can check it out. And I know people are going to be upset that I'm doing this, but you know what? I'm just going to I just want to show truth in what works and what doesn't. So if anybody has a problem with that, well, I mean, I guess they can come talk to me or whatever, right? But I'm going to be showing people exactly what works and what doesn't. Okay, so and in this case, in John's case, it didn't work. Okay, so okay, guys, right? So I'm going to go ahead and give some more detailed explaining of the process that John actually went through with the affidavit of repudiation. Okay, so John was having some problems, right, in California, right, because that's where he lives, right. He was having problems actually recording the affidavit of repudiation document with the San Diego County Recorder's Office, right, because that's where the area he lives in, right, the county, okay, and they weren't allowing him to record this document, okay, so I mean, you can record this document in any county. You're able to. This is what is explained to us from David. Okay, you're able to do this in any county recorder's office, right? If one doesn't want to do it, right? But to make it quicker and faster, okay, John reached out to David Straight himself, okay, and David has actually found a way to actually get this document, the affidavit of repudiation, recorded in the county recorder's office, right? He found a county recorder, David, right? It's called the Pima County County Recorder's Office, right? In Arizona, right? And they actually record the document, right? And through the mail too, right? So you can actually get a hold of this county recorder's office and call them up and just explain to them, hey, I got my affidavit of repudiation. And they're probably very familiar with it, right? Because several people have done this in this county recorder's office before, okay? And so John did the same thing that David has been recommending, right? and I recommended people to, right? Because they actually do record it, right? And anyways, he sent his off, and he did this FedEx overnight, right? Because he wanted, I guess court was coming up, and he wanted it to get recorded, right, quickly. So he sent it off to the county recorder's office via FedEx overnight mail, and he even included a shipping label, a return label, to be returned overnight also, so he can get it back, right? Because that's how important it was to John, right? So he did that, right? Point is that it got recorded, and they gave him back a certified copy back of that. Okay, so that is what that certified copy that he got back. Okay, so that is what John used. Okay, in state court. Okay, to be filed in his family law case, right? With DCFS, right, where they took his kid. Okay, so he filed it in his case, right? Just like that, and then he also, I helped him write an affidavit of status document, okay, which was more detailed of the actual process that we actually did for the repudiation, and we attached that, okay, to the affidavit of status also. So it was filed in in several ways, right? Two ways really. All right, but anyways, okay. But then you saw the outcome of what happened during state court and how they didn't accept it, right? Whatever. So we said, screw it. We were going to just take it to federal court, and we were just going to file it there, and maybe they'll acknowledge it, right? Because it's a federal court, it's a court of record, right? All this and all this, right? But anyways, okay, and we did, and now you can see the outcome of that too, okay? Because I just showed you all the footage, right? But yeah, I just wanted to explain the affidavit of repudiation process a little bit more clearly, so people can have an exact idea of what it was that we did, right? So, and well, that's how it went down. Anyways, I hope that y'all share this video. Please like, share, comment. Please comment. And please subscribe to my channel, okay? Because I'm not going to be keeping anything from anybody anymore, right? I don't even think I was, right? But if I did, okay, you know what? I'm going to be more persistent on putting truth out there, okay? Because that's what needs to be done. People need to know these things, okay? So I'm actually gonna try. An idea came up, right? Where someone had told me, Michael, you should just like vlog every day for 30 days and see if you can do it. So I'm probably going to be doing that, right? Giving some updates and stuff. But anyways, catch you later.